3 days before that, most probably.
Alright, this is Rosalinda Carino versus United States District Court, District of New Jersey, stock SSL 5818-08. Ma'am, can I have your name?
Good morning, Your Honor. My name is Rosalinda Carino. As a 54-year-old retired citizen, naturalized citizen, I represent myself.
Okay. Good morning, ma'am.
Good morning.
You may be seated. Counsel, can I have your appearance?
Certainly, Your Honor. Jordan of the United States.
Alright, let's see here. There's two motions here. First is your motion. I guess you have a motion requesting that I order the defendants to answer your complaint.
That's correct.
Okay. All right, I've read the moving papers. Is there anything you want to add to that?
Oh, yes.
Okay.
You may allow me because
Yes.
it's better for me to read because I wrote this last night.
Okay.
Okay. Your Honor, there is not much for me to argue with the U.S. District Court represented in the person of Mr. Jordan Anger, here present in this room. It is very much self-explanatory. It's stated in my latest submission, of such oral argument, so that if you may allow me to relate it once more, here they are. Mr. Jordan Anger must present a positive document upon which a statement will explain why he took the place of Ms. Patricia Viniero, Ms. Jackie Lambiasis, and Mr. William C. Wong, the Chief Court Clerk of the U.S. District Court, or if not, a telephonic presence of the United States District Court Chief Judge Garrett Brown, upon whom Rosalinda's summonses were all directed to all of them, not them, no response at all from any of them. Number 2, Mr. Jordan must have in his position today a written statement from Mr. Christopher Christie stating all what he told to Rosalinda, that he does not allow ex parte communication to any judge's court. What he can only do is to do investigation of the possible crime committed against the 200 names of foreclosure listed in the name of one person, that of David Atkin, discovered by Rosalinda, that is me, named in the register of deeds, using all over and over the same stamp signature of the 2008 deposed Mercer County Judge Neil H. Schuster. Number 3, Mr. Jordan must be able to trace a record of O.CARINO versus David Atkin in the chamber of Judge Fast of the Landlord-Tenant Court in the year 2004. It was about to confirm that O.CARINO, who really was the legal landlord of 81 Street, Judge Fast saw justice on the side of the criminal. That was after he saw O.CARINO's positive evidences of conspiracy towards discrimination between Atkin and Mr. Boga that has collected the township of the O.CARINOs. Judge Fast took the desk telephone in the presence of Atkin's representative and O.CARINO and reminded all 3 lawyers who took up O.CARINO's case at different points of time and said, Mrs. O.CARINO, if only you are not in a very judge that is patient, I could have returned to you your 81 Street. But it is a procedure not to intervene in any jurisdiction outside my court. Then, what is Mr. Jordan doing here now? Mr. Jordan must be able to explain why he stands against O.CARINO if no ex parte communication allowed by Mr. Christopher Christie, as well as the United States District Court judges. What is the point of Mr. Jordan's presence in here today? His presence gives impression of harassment. Therefore, I reject Mr. Anger's motion to dismiss the case because it is not acceptable for lack of proper legal approach. I wrote this last night.
Okay. Well, it's very well
Did you
written.
receive the one that I said, oral argument on motion to final default? Did you receive this?
I did.
Yeah, notice that the polygraph has to be considered by Rosalinda to lead. The court should validate the authenticity of O.CARINO's Scottsdale Asphalt Insurance claim to be followed in accordance with the New Jersey rules and regulations.
Oh, you don't have to read the whole
Yeah,
thing.
you have that.
Yeah.
That's what it is.
Okay. Thank you very much.
You're welcome.
All right. Mr. Anger, you wish to be heard?
Your Honor, if I may,
Yes.
I know it's generally not practice for one litigant to speak to another litigant, but I would like to attempt to explain to Ms. Carino some of the issues that she's raised, although I have to confess I don't fully understand all of them.
I don't either, but that's
But,
okay.
if I may, Ms. Carino, with all due respect, well, obviously, to the court and yourself, I'm not taking anybody's place, as you suggested, but as part of the responsibilities of the United States Attorney's offices across this country, it is our responsibility to represent all federal government agencies and instrumentalities in case those agencies or instrumentalities are sued. For example, if you were to sue the United States Postal Service, my office would be forced to respond. We are literally the lawyers for the United States government. So the U.S. courthouse here in Newark is obviously a federal courthouse. It's part of the United States government. And when they are brought into litigation, the only attorneys that they could possibly hire to represent them are my office. So that's why I'm here representing the various individuals that you just listed, clerks and Judge Brown in New Jersey. So that's the role of my office, one of the roles of my office, and I have been chosen to fulfill that role. Now, I further understand that you have sent many letters to Mr. Christie, and you have called my office on a few occasions speaking to various people. I don't know if you ever spoke to Mr. Christie or not. Personally, I don't know that, but I understand you spoke to many people. And I think there's some confusion. You have said that you called our office and asked us to get involved in your litigation, and you were told that we are not allowed, and again, I was not privy to that conversation. I only heard what you said and read your correspondence. But you have suggested that the response you received was, we're not allowed to intervene and tell the judges what to do. That's true. We are not. Judges, like the judge in this courtroom, have a great deal of authority, and that authority is not to be imposed upon by individuals, whether they work for the federal government or not. Attorneys and sometimes pro se litigants come and they plead their cases to these judges, but these judges are independent individuals, and they're not. When my office, even though Mr. Christie is a very high-ranking governmental official of the federal government, he cannot and should not call a judge and say, we want you to decide this case this way. That would be inappropriate and illegal. And so, perhaps the person you spoke to understood that that was what you were requesting. You were requesting us to call a federal judge and tell that judge what to do, which we are absolutely not allowed to do. My presence here does not contradict the fact that we can't tell judges what to do. It merely represents that we have an obligation, including my office, the United States Attorney's Office, to represent any government instrumentality, whether it be the Post Office, the U.S. Army, or a federal courthouse, when they are brought into litigation. But we are not, that does not give us the authority to call those individual instrumentalities, whether it be the Post Office, the Army, or federal